Hey YouTube family and GN subs, how are you? What's going on with immigration? We got lots of stuff to unpack today. We got some new policy information. We have some real cases that I'm gonna go through. Those of you who are new to the channel, you might say, what are GN subs? GN subs are good news subscribers. These are my YouTube family. We are very close. I answer all questions in the comments. They give me good feedback on my playlist. I have a playlist of unbelievable videos that shows you step by step what to do, how to do, when to do about immigration law. It's wonderful stuff. So, hey, check out the playlist and like and subscribe and be one of our GN subs, all right? And we'd love to have you. Alrighty, so a lot to unpack today. Let's get to it. All right, a bit of good news. So there's been a lot of confusion about the medical exam when you're filing your adjustment in the US to get the green card. Do I or do I not submit the medical exam? I tell you, I've been in interviews, right before COVID, and it was crazy. The officers never knew what the policy was, what the rule was. So let's break it down. Very simple stuff, right? So the 60-day rule you've probably heard about. If you file your adjustment with the medical exam, you have to make sure that the signature by the doctor on the medical exam is within 60 days. All right, so I'll give you a real easy example. So let's say you get the medical exam on X date, right? And let's say 30 days later, you file the adjustment with that medical exam. That's within 60 days. Pretty simple stuff. Now, here's what I advise, and this is what I do so you never run into the problem. The new rule is that the medical exams now are good for 2 years, but it doesn't really matter. What I do is you don't need to file the medical exam with the adjustment, right? You can wait either for an RFE, where they will ask you for the medical exam, or at the interview, right? If there is an interview, at the interview, you have your client go at that time to get the medical exam. It'll be up to date, it'll be perfect. Whatever COVID requirements are, they will be, satisfied, in place, whatever the case may be. So that's what I do. That's what I recommend. All right, a bit of good news for F1 students, right? So there was a policy, if you're in F1 or M1 status after March of 2020, that you could take online courses. This was because of COVID, right? You could take online courses, maintain a full-time course of study, which is required under the F1 and the M1, so you don't fall out of status. Well, what has happened, immigration has a policy that has been extended for the academic year 2022 and 2023. You can have online courses. You could be in your home country abroad, taking online courses, full-time course of study. You're okay for your F1 student visa. You could travel to and from the United States on the F1. You don't have to worry about going out of status. That's a bit of good news for the upcoming academic year, continuing the same policy. Great stuff. All right, a real bit of good news. This is great news for me and my clients. All right, EB1, multinational executive, EB2, national interest waiver petitions. The I-140s now can be premium processed. You can pay $2,500. You can get those petitions expedited. This is great stuff, folks. It used to take EB1, multinational executive, a year and a half to be adjudicated, just the I-140 itself. Premium processing was not available. Now with the national interest waiver, right, that EB2 category has been extended to STEM. Awesome. Now you can premium process. You can find out whether or not you're going to get a green card within 15 days. You don't need a job offer for the national interest waiver. This is good stuff, folks. Immigration new policy. They want to approve these NIW cases. I'm taking on lots of them, and we're going to be successful. We're going to get approvals for green card in record time. So we file the I-140, premium process, see if we get the approval real quick, and then we file the adjustment after we get the approval. Sometimes, depending on status, you can even concurrent filing. You could do both the I-45 and the I-140 at the same time. Voila, it's great stuff. All right, the American Immigration Council. These are these really good lawyers that sue immigration all the time. You may have heard a little bit about the delays on citizenship N-400 applications taking really a long time. But what happened was at the National Records Center where the green card file sits. Because of COVID, they have no employees, so they were backed up with requests for the green card file to get to USCIS for this naturalization interview, and that caused substantial delay. The lawyers at American Immigration Council said, no. We're going to sue immigration. There's no reason for this delay. Have these interviews for the N-400s. I'm seeing some of these old cases now. Yes, interviews are being scheduled. Good stuff. Another bit of good news, asylum at the border, new policy. So those coming into the U.S., if they're placed in expedited removal under the old cases in Title 42 and the Trump administration, etc., they just removed them and sent them back, right? So now you have a removal order, you're banned for 5 years, can't come back. Even if you have a credible fear or an asylum request, right? You couldn't make that request. Well, now you can, right? You're at the border. If you're placed in removal proceedings after, May of 2022, if you claim a credible fear of persecution, that is not an asylum claim. That's a credible fear determination, it's called. You will then be placed in detention. You will not be sent back to Mexico. You will not be removed. You will be placed into detention and you will have a hearing by phone. If you pass the credible fear determination, you will then be placed in removal proceedings and you will be able to have your claim in front of an immigration judge, all right? That's pretty recent stuff, very good stuff. Good to hear. All right, let's talk about some real cases, folks. All right, a lot of you don't know this, so this is just my experience of 35 years. So I had a client works for a huge baseball agency here in the U.S. His son was back home in Japan, and we filed for the green card for the father. The son wasn't then coming to the U.S., so we filed for the father. We got the father's green card. All right, so years go by, 2 years, it was in this case 3 years went by, and the son, still under 21 years of age, wanted to get the green card. So what we did was we filed what's called a following to join. The son can get a green card. If he qualified, still under 21, it's called following to join. A lot of people don't know this. We filed the adjustment for the son, and guess what? Look at this, 3 months. Approved. Son gets a green card. All right. That's fantastic stuff, folks. All right. Let's look at this real time. Again, this is real time stuff, folks. All right. Filed the adjustment February of 2022. We got an interview. 3 months. I-485. Good stuff. I'm finding again the trend is continuing. Filing after January of 2022. Fantastic stuff. Quick adjudications, N-400, I-485s, etc. On the older cases, what I'm finding, again, if you do the inquiry and you're proactive, waiver of the final interview. This is good stuff, folks. This is great stuff. We're in June 2022 and things are happening. All right, final real case. You probably don't know what this is, right? I-360. Hey, religious worker, fourth preference, employment-based application. I'm still getting approvals, folks, and here's the adjustment. It took a little while because it's a very rare case right now that you get approvals of, these I-360 religious workers. Hey, but we're still doing it, guys. Hey, thanks so much for watching GrayLaw TV. Click below, like and subscribe, go to the playlist. We just hit 60,000 and over 4.5 million views. We love you guys. Thank you so much. We really appreciate you. And we'll see you next week.